Thank you, Cameron. On behalf of the Office of Community-Oriented Policing Services and the Institute for Intergovernmental Research, we'd like to welcome you to today's Life Cycle of a Labor Trafficking Case webinar, focusing on labor trafficking investigations. Topics for this webinar will include common vulnerabilities of trafficking, common labor trafficking work sites, discovery methods, and investigative strategies, and a use of multidisciplinary teams to manage and prosecute labor trafficking cases. I'll now hand it over to Carolyn Bender, the IAR Program Manager for this project, who will provide speaker introductions.
Thank you so much, Nazmia, and welcome everybody. We would like to extend our appreciation this afternoon to our subject matter expert team and our speakers for this webinar, Ms. Flory Burke, Ambassador Louis C. DeBaca, and Attorney Terry Coonan. Flory Burke is a consultant on human trafficking to governmental and non-governmental agencies. She's a leading expert on the victim-centered approach in human trafficking cases and collaborative efforts of criminal justice actors and victim care providers with more than 2 decades of experience. She's the founder of Freedom Network USA. Ms. Burke is a trainer, speaker, and consultant on human trafficking issues, trauma, torture, gender violence, and exploitation, both in the United States and internationally. Ambassador Louis C. DeBaca is a former diplomat and prosecutor who has served at the U.S. State Department as ambassador at large to monitor and combat human trafficking in person, as the previous director of the United States Department of Justice's Office of Sex Offender Monitoring, Apprehending, Registering, and Tracking. Former federal prosecutor in the Civil Rights Division, he led investigations and prosecutions of dozens of forced labor and sex trafficking cases involving hundreds of victims, as well as guided policy efforts that led to the development of the modern victim-centered approach. Victim protections such as the T-Visa, the U.S. Trafficking Victims Protection Act, and the United Nations Anti-Trafficking Protocol. Attorney Terry Coonan is an attorney and professor of law and criminology at Florida State University and founding executive director of FSU's Center for the Advancement of Human Rights, which has done leading work nationwide on human trafficking issues. He litigates pro bono cases on behalf of trafficking victims throughout Florida, and he has been a consultant on human trafficking issues with the U.S. Department of Justice, law enforcement officials, and service providers nationwide. And this afternoon, we'd also like to give a special welcome to Assistant United States Attorney Mary Kucera from the Executive Office of United States Attorneys. She's a Civil Rights and Human Trafficking Program Manager and has been supporting this program. So thank you for joining us this afternoon. And at this point, I'll turn it over to Ambassador DeBaca.
Thank you, Caroline, and thank you everyone from our colleagues at IAR, and welcome to all of our attendees. Today we're going to go through the labor trafficking life cycle with reflections and hopefully some helpful tips from our experiences over the years. For those of you who've been attending these webinars before, you'll see that we're trying to build on the earlier sessions, so there'll be some review slides as well as some new concepts. I'd be remiss today if I didn't mention that we're missing our colleagues, survivor expert Evelyn Chumbow and Detective Megan Zettner this week. They'll be back in future episodes, and we'll be striving today to take their experiences and interventions into account as we walk you through the life cycle of a labor trafficking case. Now, many jurisdictions' first introduction to human trafficking is through sex trafficking, and many are continuing to use traditional investigative techniques that come from vice enforcement, especially around online commercial sexual exploitation of children. And I'll just warn you today that labor trafficking is going to stretch you in new ways and tap a new set of skills. So let's review the concept. Terry, could you give us a good, fast baseline definition of what is it we're talking about when we talk about labor trafficking?
Absolutely, Lou. I think in general, probably the shorthand would simply be coerced labor of a whole host of different kinds. The Trafficking Victim Protection Act back in 2000 actually laid out the legal requirements for what constitutes labor trafficking. It's interesting. The law establishes that it's a segmented crime. It actually lists a whole number of different things, different, in a sense, separate crimes that can all be considered labor trafficking. It can be recruiting, harboring, transporting, providing, or obtaining someone for labor or services that use force, fraud, or coercion for the purpose of subjecting that person to that kind of coerced employment. What's interesting is that you don't need all of those elements to prove up labor trafficking. Any single one of them can constitute labor trafficking, but most importantly, it does not require movement. Despite the title, trafficking, which we often suggest some kind of movement, it really does not, and legally very, very important that at the end of the day, it's about exploiting someone, not about moving them. So we see it in a host of different areas of our economy. We've seen it all over the country in all 50 states. So it's very much part of sadly, the kind of the global market that we actually live with now. And we'll, I think, run through a number of those very specific instances today where we continue to see this.
Well, one thing in particular, Terry, you mentioned recruitment, and it seems to me like it's worth stopping on that for 1 second. One of the reasons why the Trafficking Victims Protection Act added all of this was to reach all of the life cycle of a trafficking situation. And in recruitment and transportation phases have often been under-investigated or maybe even misdiagnosed as simple fraud cases or alien smuggling. Flory, what have you seen about how important the recruitment stage is to the subsequent exploitation of the victims?
I think it's critically important because it answers questions that people have about labor trafficking, such as how did this happen? Why did this happen? How did these people get into this? So the recruitment can take many forms depending on the type of work. There are often ads placed in newspapers that look very legitimate and entice people to apply. Recruiters can have a word-of-mouth network telling people about these great jobs that are available. In domestic servitude cases, we often see friends or relatives recommending a situation. So there's a whole gamut of recruitment techniques. And the thing is that the people that answer these recruiting outreach methods are individuals that are desperate for work. They're really looking for jobs. They need to support themselves. They need to support their families. They need a better life. And so they answer in good faith these techniques and are often given what look to be legitimate contracts, often given promises of certain kinds of pay scale, living situations. Some people are told that yes, you can become a nurse, you can get an education. So there are many things that are mentioned within the recruitment, and it sort of sets the stage for further treatment and further exploitation.
Well, in some ways it sounds like, this isn't what a lot of people think of as far as kidnapping. It sounds almost more like they're preying on people's hopes and figuring out what kind of pitch the person would be particularly vulnerable to. Terry, could you maybe help us think a little bit about how false promises about things like education and how people might be treated could have an impact on somebody's decision to take an opportunity, as Flory has mentioned?
And what we see time and again in these cases is that it's really the American dream that's often being exploited, that it's the promise of a better life, an education. We've seen labor trafficking cases that where the initial sort of recruiting, if you wanted to call it that, it was the promise of a relationship. So that, it's always something, the grass is somehow greener. And this is, it's a sales pitch that works repeatedly, and especially for folks that continue to look at America as a place of promise. We all know as Americans, we've had financial and economic issues in the last 2 decades, but boy, it continues to be the American dream that is pitched. What we're seeing, though, as well, is that it's not just foreign national victims, and that we're seeing a lot of our own vulnerable U.S. citizens also be exploited with some of these same kind of false promises or hopes. Many of the cases that we're seeing now involve homeless victims or at times special needs U.S. citizens, so that it's a vulnerability of any kind that a trafficker can exploit, and it's the promise that the grass is greener, I have a great job, this is the place where you will find the life that you've been meant to live, and that works on U.S. citizens and foreign national victims alike.
Well, it sounds like the people who've been victimized in this way may be deeply embarrassed that they fell for that kind of a promise once they figured out what the reality was.
I think, yeah, and that's, I think, one more reason why a lot of our victims, our survivors, don't necessarily come forward. Many of them may compare their situation here to what it was like in their home country. They may not think that, relatively speaking, it's much worse, but it's very clear under U.S. legal terms that this kind of forced labor or labor in which people are unable to walk away from their employment situation, that's illegal. We call it labor trafficking, human trafficking here in the United States.
And it seems like because of that lack of maybe self-identification, or at first they don't necessarily see it as them having rights that they might have not known from back in the home country, we often have to start with some kind of proxy, something that we can see that suggests to us that there might be a servitude situation. And of course, one of the rough proxies is what are the different parts of the economy where this seems to crop up again and again over the years. And we've got a slide here that we'll put up on common work sites. And I'd love to call everybody's attention to these hotspots on this particular slide: agriculture, cleaning, domestic, restaurants, strip clubs, nail salons, etc. But I would also say that there's a real risk that we might, by classifying things as labor trafficking as opposed to sex trafficking, a real risk that we might overlook the sexual aspects of labor trafficking cases. Something like a strip club or a massage parlor might seem to make sense that there might be a sexual aspect, but we certainly have seen sexual abuse in almost every sector, including all male fishing or all male workplaces like the fishing sector or the lumber sector. I guess the main point here is that if something arises in these sectors listed on the slide, the common work sites, doesn't necessarily mean it's a trafficking case, but certainly it's something that we should approach on very high alert if somebody in one of those situations comes forward as having been assaulted, as having sought help from their local law enforcement or service providers. We've covered case identification in some of the earlier webinars, but some of the concepts I think bear repeating, because discovery is obviously how we're going to start the life cycle of the case, being open to understanding that there are those particular types of jobs that are dangerous and dirty and demeaning that might be subject to abuse in the previous slide. But I think that one of the things that we have to stand up against is this trope that you see on television shows or movies of the immediately grateful victim breathlessly thanking their rescues at the moment of a raid or some other type of intervention. Might not be totally fictionalized, but I don't think that that's most of the folks who've worked these cases. That's not necessarily their experience, whether they're coming in from law enforcement or whether they're on the victim services side or the survivors themselves. Carrie, how accurate is that notion of the law enforcement coming through the door and the grateful victims immediately running into their arms?
Not accurate at all, Lou. Hollywood once again does us a disservice when they kind of portray that. even what we refer to as the iconic victim, this idea that, yeah, it's a victim who's vulnerable, who is rescued by law enforcement and grateful to be rescued. Very rarely happens, and that's especially the case, I think, in our labor trafficking cases. One of the things that we first of all see that many of the labor trafficking victims, they don't quite understand that they're, of course, victims of labor trafficking, that, it's a definition, a legal definition that's completely foreign to them. I had an agricultural victim that I was interviewing on behalf of law enforcement in Central Florida who told me that, well, it wasn't trafficking, it was just a really crappy job. He'd been beaten, he'd been starved, and he hadn't been paid in about 6 months. And we had to explain to him that when we see all those things add up, that in the United States, we define that as labor trafficking. But very often in our labor trafficking cases, well, first of all, they don't present as a labor trafficking case. I think it's rare that law enforcement will come upon a case that immediately jumps out as labor trafficking. Here in Florida alone, we have seen labor trafficking cases that actually started when law enforcement went and thought it was a domestic violence call, but the young 15-year-old girl from Guatemala who was in the corner, afraid to say anything at all, law enforcement thought they were there to investigate the wife being beaten, but in fact the argument was over that child being a slave. We've seen agricultural cases that open when in a barroom brawl that was called into law enforcement as an assault, someone was said to another, "I owe you," or "I own you." We had another case that started with the Environmental Protection Agency. The trafficker was dumping his outhouses from his forced labor camp directly into the St. Johns River. So these cases, I think, very rarely present initially to law enforcement as labor trafficking or human trafficking. And that's where law enforcement really has to scratch beneath the surface, do not just good interviews, but oftentimes repeated interviews. If workers are undocumented, they may also be very, very leery of talking to law enforcement or describing the reality of their situations.
And I think that, what we see on this particular slide, and I know that the slides will be available for folks. We're not doing the kind of European version of reading all the slides to everybody. But, these are certainly some good indicators that folks should have front of mind. But especially that notion of kind of when people are feeling trapped, have been treated unfairly, there's been that type of abuse or malnourishment. But it seems like there's a lot of, sometimes, I guess for lack of a better word, mixed signals and manipulation. And I think a lot of folks on the call may actually already understand that from work in domestic violence or sexual violence. That idea of code switching between the good days and the bad days, the dependency maybe that the victims might end up having on their abusers. The idea that, why didn't she run away? Well, why don't they run away? Lori, what kind of an impact can it have on a worker in one of these situations when there are those kind of good days, maybe birthday parties and rewards at work, maybe even being paid, as well as the coercion and abuse?
Well, this comes to the whole idea of psychological coercion, and it's one of the more complex parts of the whole paradigm of human trafficking. And I think it's hard for some people to understand, and certainly when it gets into the courtroom, it becomes a difficult thing. So the way I look at it is that it's one more way that traffickers control their victims. They exert control by, they're not going to punish people and have horrible situations going on 24/7. That just is not the norm. So the manipulation comes when victims are kept off balance. And the way they're kept off balance is by being rewarded every now and then. This keeps a person in their employ, under their control, because victims think, oh, things will improve. And they're often given additional false hopes. there are good days. There are even happy times. And as an expert witness, I've seen this time and time again in court, and those of us that work in this field have taken to calling certain exhibits the happy slave photos. There was a case that I worked on of hospitality workers that were moved between Florida and New York, depending on the season, and they were from another country. But on the trip, they were photographed at every scenic stop, and they were smiling, and it said, "Welcome to such and such," and this and that. And of course, and when I asked them about it, they said, "We were so happy because we were traveling. We were seeing new sights. We weren't working." And so then these photos, of course, were brought up by the defense team and said, "Look, they're not being abused. They're happy." And this happens in domestic servitude cases where traffickers are anxious to show that their workers are part of the family, so they manage to photograph them at family events. I really think it's a means of control and, once again, of keeping people off balance, and it's why that whole portion of the TVPA where it speaks to psychological coercion is so important. That abuse is not always physical, it's not always sexual, it's not always something that can be seen or exhibited. So this is one of the more nuanced, complex parts of the picture.
Well, and I think that one of the other things we see is it's not just, being nice to them or, taking them on sightseeing and things, but even just the notion of paying them. Lori, I don't know if you remember or not a case that you and I had worked on some years ago where one of the men didn't just believe that the traffickers had bought him a car. He was very proud of the car, even though they never really let him drive it.
Yeah. There's all kinds of ways that people are rewarded, and the notion that people are never paid is false, because certainly sometimes they are. Rarely are they paid what they're supposed to be paid. But yes, these I think the traffickers get very wily and are able to convince their victims of things such as, "We bought you this car, isn't this great?" And then this guy being so proud that he had a car.
Yeah, I mean, I think that, this idea of kind of the psychological, and, those aren't necessarily the kind of things that you're going to tell your precinct captain or your supervisor in the prosecutor's office. When they hear that kind of a story, they're not maybe going to necessarily think of that as a human trafficking case or worth you spending time on. And so one of the things that we've talked about in prior webinars is this idea of having a multidisciplinary team that's kind of pre-assembled so people could be wrestling with these issues before they even see that first case, so that they can understand these situations that might seem strange at first blush. Lori, could you briefly remind us a little bit about multidisciplinary teams and their value?
Sure. I like what you said about pre-established, because I think it's really incumbent on all of us in this field to try to work on our relationships and build our networks of people from other disciplines, so that when we get hit with a case, we're ready to go. I can't stress enough the importance of this, and I think that I've seen this over the years, since the 90s, before that we even had the TVPA, that we had worked on what we didn't know what to call, but they were trafficking cases, and we found that we needed to work with people that we weren't always used to working with, and we weren't always comfortable working with. But it's time to park our egos at the door and learn to use the expertise and the skills of other actors, and to be able to mobilize quickly We don't want to overburden any one of the systems involved, and that's why it's so important to have this coordinated approach and really know how to go after a case in a way that's efficient and victim-centered and has positive results. I mean, we want to have a healthy victim, and we want to punish the traffickers.
Well, so let's assume that we've got a good multidisciplinary team in place and that we've been able to recognize that there might be a human trafficking case out there. We've seen, again, we've reviewed this a bit in prior webinars, and we'll do this kind of as a review slide, of some of the investigative concerns and investigative strategies. Could you, Terry, would you be able to maybe give us a bit of a spin through the investigative strategies?
Sure, and these are strategies that, of course, continue to evolve, Lou, but that what we're seeing probably that most of them, almost all of them have in common is that, again, as we've mentioned before, many of them don't initially present as a human trafficking case. So understanding that and scratching beneath the surface, we talk in general about how human trafficking involves a victim-centered approach here in the United States, which I think has been true, and it's so vital as a national response. But these cases are also victim-centered, and a number of our prosecutors have reflected that without a victim witness, many times they will not have a case. So that I think as law enforcement or as prosecutors, that always has to be kind of foremost in our minds. This is where, of course, stabilizing that victim or that group of victims will be really important right from the very outset of the case. In the research that our Human Rights Center here at Florida State University had done, we found that whether it was sex trafficking or labor trafficking victims, their greatest concern was for their own physical safety, their own ability to be protected from their traffickers when they were first extricated from a trafficking situation. So that's first and foremost. It also points to the importance of folks like Flory and folks in our non-governmental organizations world, that they are the ones that are going to step in and do that victim care. And as Flory mentioned, that's where these multidisciplinary teams are so important, so that law enforcement and prosecutors can call a service provider that they already know and trust. As the investigations go forward, though, what I think is extremely important, it's this notion of corroboration. Thinking of it in terms of from law enforcement, also a prosecutor perspective, search warrants become really critical. And what we're seeing around the United States is that oftentimes a state search warrant is more accessible, easier to obtain, and that a great many of our labor trafficking cases, though they may go federal, many of them start with search warrants that are secured under state law. So that's, I think, an interesting and a quite relevant trend that we're seeing there. In types of evidence, so much of a labor trafficking case will come down to financial records, that very often it's the records that are going to be in the Department of Financial Services in a state office building. Find out, was there health care benefits being provided for those victims? Were, again, the different kinds of financial requirements that are obligations for employers, are those, or were they in place? And that were they not, it's going to be the lack thereof that may point to trafficking. Very important, too, so many of the traffickers that we see nationwide, when it comes to businesses, are subcontractors. And this is this nature of, again, the global markets that we work with, but that, again, it's maybe not the larger employer or the larger firm, but it's a subcontractor who's cutting the grass, who's providing the services on a golf course, who's providing the workers that can pick oranges. They are the ones that may actually be involved. That will bring up questions of willful blindness. In general, though, we need to also think about other violations, wage and hour violations, immigration violations, and as prosecutors, always to think about RICO statutes. Almost every trafficking case will involve some dimension of organized crime, and virtually every state now has RICO statutes that very much encompass human trafficking offenses, and those should be looked at as well.
Well, and hopefully, by the time we get to this point where we're considering whether we should look at some of our organized crime tools, what our search warrants are going to look like, what our how our case should proceed, we've identified that it's likely a labor trafficking case. We've stabilized the victims and worked with the service providers on our task force to make sure that they have advocacy and that they have health care and everything else. And hopefully, maybe even we've made an arrest at this point. So I think that at that point, we start moving into something that's kind of the hybrid stage where we're moving into prosecution, whether it's immediate post-arrest investigation in the prosecution setting, or whether it's trial prep, et cetera. And as a threshold matter, you have to figure out whether things are going to be proceeding on the state level or as a federal prosecution. Labor trafficking cases have often been federal throughout the years, but we're starting to see that slowly change. But I think one of the challenges to that I'll highlight, and we'll get to this again when we talk about sentencing, is ensuring that going locally doesn't result in light sentences that thinks of these as just low-level fraud or misdemeanor assault cases. But the other threshold, frankly, is whether one should even go the criminal route at all. Terry, if you've got a client that you're working with, how do you make the decision to go criminally as opposed to doing a civil case? And what would happen to a civil case if you ended up going criminally?
Sure. Well, and you know, Lou, the conventional wisdom used to be that the civil case always followed the criminal case, and some of that was for evidentiary reasons. Oftentimes the evidence could be used in a civil case, what was established in that criminal case. That's no longer kind of an exclusive scenario. What I found in 20 years of working with survivors is that it's very important for them to see their traffickers be prosecuted, and that, again, many of them understand that it is a difficult role to be a victim witness. It requires oftentimes a non-governmental organization to be right there with that victim witness to help prep them for what will inevitably be the difficult task of confronting their traffickers in open court and being subjected, of course, to cross-examination. But again, a victim that's been well prepared and well stabilized will oftentimes find that that can also be kind of a cathartic experience, that they can actually find that, wow, the law does represent them and that they weren't the ones with power in this situation of exploitation. So a number of our victims have reflected with us afterwards that it was actually very important, though difficult, for them to basically serve as victim witnesses. Equally important is the whole notion of a civil lawsuit. I mean, that is literally, that puts the victim in the driver's seat. It also is meant to make them whole, and that they are finally able to, number one, understand that they are very much the drivers of that case. That case is all about their losses. That case is about, again, them having been exploited and them finally being able to make that person accountable to them personally, not just a prison sentence, but to actually have to be in open court and oftentimes pay civil damages to them. Civil damages are far more available under federal law right now. That's still a work in progress in a great many of our states. And the work I do with state legislatures or judges around the country, we do see that even here in Florida, there's been tremendous resistance to punitive damages for trafficking victims. It's a battle we're still fighting. But that's so very important because it literally makes the victim whole. It also sends the message, again, the whole purpose of punitive damages, that, again, we in America do not tolerate this. We'll not only make the victim whole, but we will further punish that trafficker. So whenever possible, we think that's extremely important as well.
Yeah, you know, I think that one of the things that we see when we're doing this, if you can make that decision between, you know, should we go civilly or should we go criminally, obviously there's charging decisions that have to be made, whether you're a plaintiff's lawyer or whether you're a prosecutor. And I think that, you know, one of the things that we'll often see, and I know historically has been encouraged, is to come in with a kind of a simple charge, an immigration charge or, you know, something like that, so that you could hold the defendant while stabilizing the victims, and then start to get the more in-depth account, and then supersede up to more complex charges. And I guess it begs the question as to whether or not somebody should even really charge the slavery offense or not, or whether it's easier to just do the cleaner case of alien harboring, etc. Now, I'd certainly refer everybody to our friends over at the Executive Office of U.S. Attorneys. Mary Cacero's on the line with us, but also the folks over at the Human Trafficking Prosecutions Unit at the Civil Rights Division as to kind of where they are on this right now. But I think that it's, the idea of doing an aliens harboring for financial gain or something like that, really, at the end of the day, there are some reasons to do the harder case, the slavery case, the forced labor case, the human trafficking case. Since the 13th Amendment and the right to be free in America is really the issue here, the victim's rights just aren't vindicated by a harboring or an assault conviction. That's the state's interest in border security or keeping the peace, and that's a different state interest in ensuring that the folks aren't enslaved. If you do things under other statutes, those people who count crimes for a living, whether it's TRAC, EOUSA, FBI, Unified Crime Reporting, etc., might not end up picking them up, and you'll end up having the ongoing undercount of labor trafficking that happens here in the United States. Doesn't mean not to sometimes plead somebody out to those lesser offenses, but I think that there's so many things that flow from a case being properly seen as trafficking and slavery, whether it's the sentencing conviction or considerations, mandatory restitution, remission and restoration, and it may even help victims with issues of other criminal acts that they might have had to commit on behalf of the defendants when they were in the servitude situation. I guess in other words, if you don't do something as a slavery offense, then you should, as much as possible, explain to the world that it still is a human trafficking matter, but that you just pled it out to that other crime or charge that other crime because of the interests of justice. So with that, I want to talk very briefly about charges and putting together your charges and allegations with trial in mind, building in the evidentiary issues that you know are going to be out there, weaving together, whether it's through conspiracy, attempt, or other joint liability provisions in your state statute or in the federal code, so that you can attribute overt acts to everybody in the conspiracy and really demonstrate that this is part of an ongoing scheme, pattern, ongoing course of conduct. It allows you to set your time frame, and it may even allow you to plead different situations where you might have more than one generation of victims. One group who is enslaved and escapes, another group who's brought in to replace them. They might not even really know about each other, but that's part of the same scheme, plan, or pattern on the part of these co-conspirators. One of the things that's, I think, very important for folks to think about in pleading, and especially if you're in a place like in the federal system where you can do a speaking indictment, is really using the indictment to educate the judges and the defense attorneys for the lower level folks who you might want to approach on what the law is. This idea that you can show that compulsion and the coercion by establishing an overarching climate of fear rather than kind of a hands-on kidnapping and beating of one individual person. And as Terry mentioned earlier, now there is kind of this idea of benefiting from or profiting from a human trafficking situation. And so thinking about the science of the requirements and the standards in the new last 10 years worth of the Trafficking Victims Protection Act, where you can show that somebody was involved through reckless disregard or that they were participating in a business venture that was making money off of enslaving their folks. Great way to go up the food chain a little bit, not just getting the, say for instance, the abusive crew leader, but getting the farmer who's been making money off of this all this time. I think the other thing that one has to really point out at the beginning of the case, when you're pleading the case, but also as you are preparing it with trial in mind, is that victims in these cases have rights. They have rights to certain programs that were created specifically by Congress to address issues in these cases, and and rights that a lot of states have now put into play. Don't be shy about making sure that all these folks have the benefits and services that they need. Don't deny or delay a T visa certification or housing, clothing, job assistance, things like that. It's better that those people are recovered and they might have to face some cross-examination than having them still in trauma and then bringing them in and re-traumatizing them because they haven't had a chance to heal. My experience certainly in court is if the folks have had time to recover, if they've had time to get on with their lives and put themselves together emotionally with the help of a good team, then they're going to be able to withstand any kind of cross-examination as to whether or not they're simply saying things to obtain benefits from the government or if the government coached them, etc. So don't be afraid of those things. They're going to happen anyway, so you just as well protect your victim witnesses to the fullest extent of the law and the programs. Just make sure to disclose everything, obviously. You don't want to end up having the entire thing later get overturned on appeal because of any kind of disclosure issues. You don't want to go shopping for Brady or Giglio problems. I think finally the notion of preparing your witnesses. This is not a situation where you're going to want to put a witness in cold. You shouldn't be afraid of prepping your witnesses, both as far as what they may end up saying on direct examination, but also even to prepare them for what kind of cross-examination they might face. Flory, you've certainly seen how people are reacting when they're put on the stand or in the investigative side as far as telling their story and how that story unfolds.
Yes. It's another one of the complicated issues about how the story unfolds. And the more people are treated well and provided with what they're entitled to, the better they'll be as a witness. And I liked that you said, Lou, about having them recovered enough to be able to testify rather than still being in a traumatic situation or mindset. And also, when they're not provided things, they can get very angry at being asked to testify. And, you know, practical needs need to be attended to before people can give some kind of coherent story. So I do a lot of teaching of interviewing skills that happen way before the courtroom scene. They start way back at the investigation. And I think it's really critical, and it sort of goes through the life cycle of the case. People need, all the professionals working with these victims need to understand that stories are probably not going to be told in a linear fashion. They're not going to be complete. I know it causes great frustration among our law enforcement partners who have time constraints, etc. But we have to expect that there will be contradictions and take the time to look into them, understand the psychology of victims. Many of them have been fed a false narrative over time, so much so that it gets interwoven with the facts of their life and facts of their experience. We need to have professionals understand that there's a fear element about us. Victims want to please us. We're helping them, so they want to say the right thing. We need to convince them it's not about saying the right thing. It's about saying the truth, what happened. There's still fear of being deported, of being punished. You know, these threats that have been made to them as a means of power and control, they last a long time, way after someone is liberated from a trafficking situation. So I think that, you know, the patience and the skillful interviewing techniques, the way to ask questions, not going after the list of yes/no answers, but taking the time and following up on a response of someone, and being very truthful about what the court procedures will be like if they get to that point, what it will be like to face the person who trafficked them, what will they be expected to do, to say, how to act. And, you know, the best advice that I have is just really try to get the person at ease and say, you are the story, you are the expert here, you're the one that knows what happened to you, and what you need to do is convey that. Because it's up to the attorneys, it's up to an expert witness, if they're called in a case, to lay out the other facts and instructions and nuances and complexities of what human trafficking is. And really, the victim just needs to tell what happened to them.
You know, one of the things, go ahead, sorry, Flora.
So I was going to say that, you know, prep by the prosecutor's team is really important. That you need to be sensitive to the needs of the victim, and I think most people are.
You know, I think that, as you mentioned, that idea of making it so that the only thing the victim has to do when they come into court is tell their story, tell the truth, and everything else is kind of prepared for that moment. And one of the ways to do that is through really teeing up and educating the judge. And some of that ends up being part of the litigation of the case itself in the pretrial stage. Terry, can you talk to us a little bit about some of the ways that you can educate the judge in that stage before you even pick a jury?
Well, absolutely. And I think, Lou, aggressive pleadings, you know, aggressive charging is quite appropriate. That it's, again, it sets the context. It sets the stage both for a judge and eventually for a jury to understand that in many ways this is still a new crime for so many people. And to be honest, as I work with judges around the country, I understand that many of them are not real clear on it if they haven't had a case, you know, in front of them. So when we think about motions in limine, trial briefs, briefs on jury instructions, I think any opportunity that a prosecutor gets to educate the judge on even some of the new kind of evolving legal concepts are really important. One of the most important ones that I think, and I've looked at this in a number of kind of trials around the country, but the notion of a climate of fear. I think too often maybe we instinctively want to look for a magic moment in which someone was told by another, I own you, I'm enslaving you. But the reauthorizations of the Trafficking Victim Protection Act have made very clear and that this notion of how fear can be incrementally built up through a whole host of different efforts or different small things, that I think educating judges on what that climate of fear looks like, and I think there's a whole host of related issues, basically demonstrating or once again conveying to a judge that there's no affirmative duty to escape on the part of a victim. The fact that they can at times come and go does not mean that they're not trafficking victims. That they are somehow have been paid, that's really not a defense. An initial agreement to work is not a waiver of subsequent coercion. And that very importantly in many of the foreign national cases we see, defense attorneys I think are resorting to what we might call a cultural defense, this idea that, well, it was okay in their culture to do this sort of thing, and they expected it even as workers, that, you know, they'd be taken advantage of. That's all, I think, so very important. I think, too, always being mindful of some of the other things. The dynamic of document servitude. Again, we have a 1592 statute that also criminalizes that. We're seeing that in a host of situations where people's documents are simply taken away from them. We see psychological coercion increasingly in these labor trafficking cases. Many of the traffickers themselves are savvy. They avoid the beatings. They avoid the quite overt physical acts, but the climate of fear and the psychological coercion is, I think, a real common denominator. Lou, a question for you. What's your thinking as a former prosecutor on plea deals? I know there's a number of different schools of thought about those.
Well, I certainly think that, it's kind of like Michelangelo. You start out with a great big lump of clay and you try to whittle it down until there's a beautiful statue. That's the only thing that's left. And I think that somehow, especially when you have a multi-defendant case, what you optimally end up doing is try to get rid of the folks that are going to be a problem, try to get rid of folks that you can then work with, and really pare down the cast of characters so that you can tell the story that most accurately reflects what happened to the victims and the survivors. As I mentioned earlier, kind of leaving the slavery and servitude and trafficking mode might need to be done, but preferably, why not look at that Section 1592 that you just mentioned as far as document servitude? It's got a 5-year cap, and you can tell a defense attorney that you'll be able to cap this guy, as well as at the same time bringing in the fact that it was coercion and service. The reason I talk about caps or things like that is this notion of sentencing consideration or statutory caps for a particular type of crime is certainly a really effective way of what we would call flipping the low-level or kind of side-level folks against the main perpetrators. I think it's really important to listen to the survivors and listen to the victims. They're going to know the difference between the guard who was nice to them or maybe felt bad about what was happening to them as opposed to the one who was taking liberties with the female workers or was abusing people in other ways. And you don't want to come in and lose all of your credibility with them by cutting a deal with one of the worst guys. On the other hand, you also don't want to do that because then it wouldn't be an accurate reflection of what had happened to them. So I think that we sometimes see abused spouses. You mentioned that case where there was a domestic abuse situation, and the girl who was a domestic servant in the house, that he was prosecuted for that. Well, the wife was good for that as well. She was involved. But at the same time, we recognize that she was an abused spouse, that she wasn't in the same position of power as he was. And so I think in that case, if I recall right, we used misprision of a felony as a way to come up with a just negotiated resolution. I think one of the other things that we have to take into account, though, with restitution is, restitution as part of a plea deal, having them agree to it up front. So you send the signal to everybody that we're going to be looking at restitution all the way through this case, not just, when the big guy hopefully gets convicted, but everybody is going to be jointly and severally liable for restitution. Now, restitution, I think, has as much of an important of a public and private effect as a long prison sentence might, but Terry, it seems like restitution has turned out to be almost a bit of more of a challenge than we thought it was going to be when we passed the TVPA. The TVPA says, mandatory restitution. What's happened to that?
Lou, that's the question that a great many of us are asking across America. A very good report from the Human Trafficking Legal Center that notes just how often the mandatory restitution is not being ordered. And it's, I think, one of the gaps, one of the oversights that we still have to address. The TVPA has very, very powerful restitution statutes. It requires, the greater of two measures, either the Fair Labor Standards Act minimum wage, and important to recall that when we're gauging that number, anything that a victim works over 40 hours is time and a half. Waiting time is covered. So it's not just the raw hours that might be worked, but again, that larger figure of hours, that's the FLSA gauge, or the benefits to the defendants, literally what they were charging the clients or others for the fruits of their victims' labor. And that at times will be the higher of those two measures. So yeah, a very, very important and often neglected part of our federal statute. It is encouraging, however, a great many of the states, actually all 50 of our states now have anti-trafficking statutes. It's taken the better part of 15 years for that to happen. But almost every single one of them has a restitution statute as well, so that whether we're looking at federal court or state court, restitution absolutely vital.
You know, and I think that one of the things that we have to think about is, you know, restitution is not going to prevent us from doing the kind of asset forfeiture and seizure work that so many of us are used to doing. There's actually a way, and I certainly would encourage everyone, not only for the prosecutors, but for the victim advocates to work together to be able to apply to the Treasury and get that money back. That's perfectly legal, and in fact, Congress acted to make that a certainty a few years ago. The other thing I think in sentencing, as long as we're talking about sentencing, you know, I do think that we have to address the fact that sentencing in labor trafficking cases is lower than in sex cases, and that's not surprising if there's sexual abuse, but as we've seen, there often is sexual and horrible physical abuse in labor trafficking cases, and labor trafficking cases typically are going to end up having more situations where people are held for 10, 15, maybe even 20 years. And I think it's important for all of us to think about how this is not just a really bad wage and hour case or an occupational safety case, but rather this is a violation of a core fundamental civil right, a constitutional right here in the United States. I think that one of the things that is good, though, is that we have that federal model. The seriousness of the crime was recognized as far back as 1996, and the guidelines were raised so there wasn't a real low, for lack of a better word, going rate. For our federal participants on the call, I certainly urge you to aggressively seek the enhancements under the servitude guidelines, whether it's the vulnerable victim enhancements, the increase for the number of victims, or the time in servitude. And don't be shy about using the cross-references, whether it's to sexual assault or other offenses that they might have done. Again, there's more sexual abuse in labor trafficking situations than people sometimes expect. And I think that if you put that into your pleadings, if you have that charged up front, and you think about how you're going to sentence that from the beginning of your case, you're much more likely to get that in during your trial. It's not going to be prejudicial or irrelevant, but it's part of the coercion. It's part of the service in which they're being held. You know, plead that in your case in chief and argue it in sentencing, and never keep your eye off of all of the different types of abuse that folks were suffering. But I guess that, you know, to me, one of the things that's important is to not simply, you know, take our word for it so as far as abuse and what the situation of the victims were. I think it's also important at sentencing to make sure that the court can hear from the victims themselves, you know, not simply hearing it through the adversarial process or through the government lawyer or even through their own advocates. The victim impact statements in jurisdictions that have them or something like them, I think can be a very powerful tool to let the victim's voice be heard. Terry, you've helped prepare your clients and others for providing victim impact statements. Can you walk us through that a little bit?
Absolutely. And Lou, what I found, just as a victim advocate, as a legal victim advocate, this is one of the most potentially empowering moments for that victim, especially that victim witness, to have their voice heard. Many times, again, they have a mixed experience, especially of cross-examination. They feel that, you know, their credibility has been questioned. Much about their lives or who they are oftentimes has been questioned by a defense attorney. But this victim impact statement is very, very different. And again, this is also yet another place where a really good federal victim advocate, an FBI victim advocate, or ideally an attorney that victim actually has, oftentimes an immigration attorney if they're a foreign national victim, but to help them actually lay out how is it that they have been hurt by the things that the defendants did to them. And as part of, again, that sort of teachable moment, both for the judge, but in this case also for the jury, to understand here's the human cost of these labor trafficking cases. Often there's this sort of sense that, well, labor trafficking is not as bad as sex trafficking. Sex trafficking is really bad, but this is our one opportunity in the legal system to convey to judges and to juries and beyond that the amount of human suffering, the anguish that these survivors have actually gone through. And it can be a very healing moment for them. They feel their experiences and their voices are very much validated in a courtroom. For me, it's one of the most important parts of that state or federal trial.
And Flori, you've, I think, seen folks being able to tell their story or to write letters to judges as well. How have you seen that as far as people's ongoing journey of recovery and kind of leaving the trauma behind?
I think it's really important for some victims. I think that the main thing is that it has to be their choice. To me, choice is one of the most empowering things that we offer victims of trafficking, because they have had their choice, their ability to make choices, taken away from them. So it's a choice about whether they want to do this and or whether they'd rather be there in person speaking. You know, when victims have had the necessary service delivery and they've had advocates and they have more understanding of the systems that they're involved in at the present time, they often choose to do this because it will give them a chance to say things from their perspective. And I have seen some negative examples of this where service providers who were well-meaning overstepped their bounds, and they, you know, almost dictated the statement. So it wasn't really their story, and it becomes questionable. So I just caution people about that. But I think it is a real empowerment tool, as Terry said.
Well, and I think that, you know, thank you, Flori, for pointing out what I think that hopefully runs through this entire exercise, but I do think we have to remind ourselves of it. You know, when we're doing a prosecution or something in the law enforcement space, we're acting on the part of the government, we're acting on the part of society. Hopefully we're vindicating the rights of the people who've had this crime committed against them, and it is a civil rights crime, it's a human rights crime. But I think that we have to always go back to and realize that what we are accusing the defendant of is violating this person's right to be free, to choose things for themselves. And it's, I guess in some ways, it's even more problematic in a case like this if we do what sometimes on our worst days in law enforcement and prosecution and don't listen as much as we should. If we're going to vindicate their right to be free and to make choices, we've got to figure out how to let them make choices. We're going to assume for the purposes of the lifestyle exercise today that we've won the case. Bad guy's been sentenced. We're not going to talk about appeals because this isn't a legal webinar. And for a lot of people, then that means they move on. They go on to another case, et cetera. But it could be that that file goes back into the file room with a few outstanding defendants, because these are sometimes big cases that happen in different places around the country. I certainly had cases that I worked on where after we kind of closed them up, said goodbye to everybody and moved on to other cases, you know, 4, 5, 6, even 10 years later, suddenly the one of the missing defendants might get stopped at the border, might get picked up on a traffic stop, or might even, rarely, but it happens, an extradition might have successfully come through, and suddenly somebody is being sent to us through official channels. So I think it's pretty important to not ever really think that these things are over, not only because of that, but also because of the ongoing contact and the ongoing relationship that we've seen that's very healthy between investigators, prosecutors, victim service providers, and the survivors themselves. Terry, you've had some cases in Florida, I think, where folks have gotten caught years later. I remember when I first started at the Justice Department in the early 1990s, one of the first cases that a friend of mine was doing was a case from the late 1970s, the Shaw case, where a couple had fled Miami in a domestic servant situation, and we caught them coming back into the United States 24 years later. Because the FBI agent had never lost track of that woman who they had enslaved, and she was willing to go forward, we were able to make that case almost a generation after she'd suffered the abuse. Now that's a kind of extreme case, but I think you've seen other cases since then in Florida where people have been brought back to justice sometimes years later.
Well, we have, Lou, and in one sense, for those of us in the justice field, that's very heartening. The one thing that we've learned, though, is that oftentimes that then requires that victim witness who thought also that that case was behind them. They've moved on. They've started to settle. The healing process has begun. Oftentimes there then comes that expectation that they may need to testify again. So that's been one of the hitches, one of the hiccups in that kind of scenario where, as Flori mentioned, it's really all about those victims' choices as well, especially for their own health and well-being, that suddenly there's kind of an expectation or a request from, again, legal personnel that person perhaps once again testifies. So that's just one thing for us to think about, that, again, victim witnesses have gone on to try to settle, try to rebuild their lives, and then suddenly they're being asked to revisit once again what were some of the worst days of their life. Just something for us to think about in terms of what we ask of them or how we might ask them.
Well, and even if they've been, there's a small group of folks who, as they decide to get back on with their lives, one of the things that they want to do is to, become a professional or be in the advocacy role of survivors. Even those folks, when they are being a survivor advocate, they are reliving or dealing with this issue on their own terms. And I think that when suddenly a case pops back up, they are no longer necessarily in the same type of control that they had been in. But I don't want us to think too much about this life cycle of human trafficking only being about law enforcement and prosecution needs, because that life cycle of the trafficking experience for the survivor may not, in fact, almost definitely will not end when you get that email saying that the appeal is not going to go forward, or that the person has been sentenced and has been sent up to the penitentiary. Flori, can you walk us through where we are with kind of what the long-term responses are? We've talked about trauma and case management in some of the other webinars, but now we're really talking about the kind of life cycle of the person, not the life cycle of the case.
Right, and it's a critical issue right now, and it's something that I care deeply about, because I don't think we're addressing it very well. I don't think there are monetary resources available enough. A person doesn't recover overnight from these egregious situations, and lots of things need to be relearned or learned for the first time. We see cases where family reunification occurs. We have parents who haven't seen their children for years, and all of a sudden they're being, they're expected to function as a family. We have people that are getting, you talked about civil litigation and some of the monetary awards that are given in that situation. We need to provide training in how to manage finances. What's that all about? Practical skills, so that people can not be marginalized so easily, so that they can have some job skill, so that they can work. It's particularly critical now. I don't even know how to think about this. because of our current economic situation and how many people are out of work. I can't even imagine how hard it is for survivors who are just starting out. But job training, job coaching, all of those things, immigration assistance, those go on for years. And NGOs are not funded to provide that kind of assistance. You know, they're cut off after a certain number of months in providing assistance to victims of trafficking. So I think that that needs to be something that the field must look at and must address. We want to not set these survivors up for failure, and I think that's what we would be doing if these long-term needs are not met in a better way.
You know, Flori, it seems like we often gravitate towards, you know, the inspiring story of, you know, our colleague Evelyn, who's sometimes on the calls with us, usually, you know, who ended up starting out as a child domestic servant enslaved in the Maryland suburbs, and has gone all the way to being a member of the President's Advisory Council on survivors. Or we talk about, you know, folks like, I think of one of the young victims in a case that you and I had worked years ago, who was featured as Employee of the Year at his job where he cleans the Statue of Liberty for the Park Service. You know,
right.
But that's not really what we're, you know, that's not what everybody's going to end up being, that kind of iconic victim, kind of like Terry had mentioned earlier, right? We're kind of fighting for normalcy, and normalcy doesn't always result in those big, dramatic breakthroughs and being an advocate or being a publicly known person. Sometimes normalcy looks like anonymity, doesn't it?
Right. You know, I think it all depends on the individual person and what kind of resilience they're able to call forth, what their psychological makeup is, what their prior experiences, education. There's so many things that go into, you know, survivorhood for any of us, but certainly for people who have been enslaved for years. So, you know, we need to look at people as individuals and really do a better job at assessing what the needs are and how we can better address them. Because we do have many success stories, because we have a lot of good services available, but we also have people falling through the cracks. And in this period of our lives in this country, we have people falling through the cracks who were not trafficked. So it's a difficult time.
Well, I think that one of the things that we can hopefully do, not just those of us who've worked the cases together and have been able to share a bit of our experiences today on this call, as far as walking through the lifestyle of the trafficking case. You know, I was on a call this morning with a survivor activist from Canada, Rochelle Brunder, and she said something that, you know, really hit home to me, which was that we need to be a beacon of hope walking with survivors so that they can lead their own story. But we need to walk with them, and we need to help shine that light for them. And so hopefully what we've done today in the webinar, talking about the life cycle, talking about a kind of a case from beginning to end, can help all of us together walk on that journey with them, from the initial hope and excitement of recruitment to the fear and coercion of exploitation, the nervousness and unsettled adjustment of the criminal justice system, to seeing justice done in court, getting on with one's life, and maybe even becoming a survivor advocate and expert. So thank you, everybody on the call, for walking with us on that journey, but more importantly, thank you for walking with the survivors on their journey to freedom. I'll turn that back over to our friends from IIR now.
Thank you so much, team. We really appreciate your sharing your insights with us. And on behalf of the COPS office, I'd like to thank all of our participants in this webinar. For those logged into Adobe Connect, a participant survey has been sent to your device. Your feedback and your experience with this are very important to us, and your input will help us measure the effectiveness of COPS Office labor trafficking webinars in meeting your agency's goals and objectives. We hope that the information shared will be of benefit to you in your efforts to enhance the investigation of labor trafficking cases. And I would like to extend a special thanks to our speakers today for taking the time to share their knowledge. Thank you. And I think we might have a question or two there. Lou, if you have a chance, can you address those, please? Lou, are you there?
I'm sorry about that. I had put myself on mute while you were talking.
There we go. Thank you.
Yeah. Robbie Jenkins sent us a chat. Robbie is currently working at some cases with folks who are reporting that they were victims of labor trafficking who were abused while they were members of a particular church back in the 1970s and early 80s as juveniles. And Robbie was hoping to get any information that we might have about labor laws in Florida during that time and what the statute of limitations might be. I would certainly defer to our law professor from Florida State University, Terry, as far as statute of limitations and other Florida legal structures. But what I will say is that even back in the late 1970s, there were a number of cases being done in the criminal side on the federal prosecutions by my predecessors at the Civil Rights Division involving folks who were in cult situations. A lot of the cases back then, because it was pre-DPVA, they end up turning on the violence and assaults and things like that, as opposed to the broader levels of coercion that we would see under Section 1589 after the TVPA was passed in the year 2000. So there might be an issue there, depending upon what the factual allegations are as to what was happening on that. And Robbie, there might be some other things that I can help walk you through as to that particular church. There's some things I know about that, and if you reach out to I think our colleagues at IIR, maybe we can set up an offline conversation.
And Robbie, this is Terry. I would, be very happy to follow up with you on the details of that. Yeah, I think we'd run into maybe some ex post facto law questions, but I think, I'd be happy to look at our Florida statutes with you on that.
We had another question from Annie Smith about, I think I had thrown out a bunch of acronyms when I had mentioned some of the data sources on the numbers of labor trafficking prosecutions. There are several. They're not always great because what's that term? Garbage in, garbage out. If a case ends up being pled to something else, then that's what it ends up in the computer. So you can have a forced labor case that gets pled out or gets convicted under a theory of fraud in foreign labor recruiting, which is also part of the Trafficking Victims Protection Act, and it won't show up as a trafficking case because it's not in it's not in Chapter 77 of the Criminal Code, and therefore the computer at TRAC or even at the Executive Office of the U.S. Attorneys won't automatically count it, even though the AUSA or the Civil Rights Division lawyers who worked it, the FBI agents, the local police, or sheriff's deputy, the DOL, or diplomatic security agents who worked on them with that case, all know that it was a trafficking case. It might be a case that TV says and continued presence and victim services were provided by everybody, but if it doesn't have that particular number on it, then the folks who look at federal prosecutions may not count it. So there's always been a bit of an undercount. There's also an undercount in labor trafficking prosecutions because there is a undercharging of labor trafficking prosecutions. The Human Trafficking Institute just came out with a report about kind of their numbers analyzing numbers provided by the feds and others, and you're still talking about a very small percentage of the trafficking cases in the United States these days being labor trafficking. Obviously, we are all on this call together, so hopefully we're all committed to changing that percentage where justice provides. I wasn't sure if there were any other questions that we needed to address. I will certainly, I think that Caroline from IIR had put up on the chat the links not only to the track reports, but the State Department's Trafficking in Persons report every year looks at the U.S. government's activities, just like we do all 190 or so other countries in the world. And I know from experience that we're very much striving to reflect all of the cases, not simply what the computer would tell us. And so the interagency every year is really interrogating the case files to try to have that number as accurate as possible. So I'd always suggest to people to go look at the U.S. narrative in the Trafficking in Persons report. It's also just a great snapshot of what is going on around the United States in any given year on this issue. I'm not sure if we had any other questions that we can tee up for me or others. Please don't be shy.
Hey, Lou, looks like we have one person typing in the chat right now.
Okay, well, we will look forward to seeing that. I would certainly, one thing I would like to take this opportunity for, that we have that question that was coming in, Cameron, as far as will the webinar be recorded and available to everybody. And I think, Cameron, that is something that you guys are making available?
Yes. So the webinar recording will be available for future reference, and we'll make sure to take note of the request in the chat.
Excellent. I know that we have a minute or so, and if we get any others coming in, I'm going to use the moderator's prerogative in that a minute or so to do what we always should do, and that is recognize those who we've lost. Holly Weissman, who was a prosecutor in the criminal section of the Civil Rights Division and prosecuted the first labor trafficking case after the Trafficking Victims Protection Act became law, a case up in Alaska where women were being brought in thinking that they were going to be as part of a cultural exchange dance troupe. In fact, they had spent months embroidering their kind of Russian national costumes and everything else. They get to Alaska and they were enslaved in strip clubs up there. Holly was the first prosecutor to actually use Section 1589, and we lost her about 6 weeks ago. I think as we see around the country, we're all losing folks we know and love because of COVID, and we're not able to mourn them in our traditional ways. But I would certainly want to commend everyone to the memory of the good work that Holly did, trying to be out there on the cutting edge, working on behalf of not only those victims, but trafficking victims in Eastern Europe and other places in her subsequent postings. So I definitely wanted to tee that up. She was an assistant U.S. attorney in the Southern District of Mississippi until just a little bit earlier this year. And rather than the retirement that she was so looking forward to, we now, I think, end up having to mourn her memory. So thank you, IR, for giving me the time to mention and remember one of the good ones.
Thank you so much, Lou. We appreciate your sharing that with us. And I think this concludes our webinar for this afternoon. Thank you again to Lou and Flory and Terry. And we hope everybody stays safe, and we appreciate your joining us this afternoon. Thank you.